Good morning.
Good morning, my lady.
Morning, my lady.
My apologies for keeping you waiting. I thought we're starting at 10. Completely forgot that we agreed that we would start at 9. So thank you for your patience.
No problem, ma'am.
Mpo, you may call up the matter.
Thank you, my lady. As the court pleases, my lady, this is a matter between the Special Investigating Unit and 3 others and Mr. Hassan Ebrahim Kajee, case number GP22 of 2021, appearing in the Special Tribunal of South Africa, 14 September 2022. My lady.
Thank you. Counsel may place themselves on record.
May it please the court, my lady, I appear on behalf of the plaintiffs. My leader, Mr. Hubert, is on the platform. However, I will present the argument this morning. My surname is Fouchier.
Thank you, Mr. Fouchier.
Thank you, my lady.
May it please the court, my lady, I appear on behalf of the applicant, the defendant, Manilal, initial A.
Thank you, Mr. Manila. Yes, Mr. Manila.
Thank you, my lady. My lady, at the outset, I seek the court's leave to accept the amended heads of argument. My lady, the amended heads of argument deals mainly with, or in fact, virtually totally, with typographical and grammatical errors that occurred in respect of the initial heads of argument. I have caused a letter to be addressed to the plaintiff's attorneys with regard to the amendments and requested if there are any objections. As at date, I don't believe that there are any objections. In the circumstances, if there are no objections from my learned colleague, I will ask that the court accepts the amended heads of argument, my lady.
Mr. Fouchier?
Lady, I had sight of those amended heads. I contacted, or I attempted to contact my attorney this morning. I couldn't get hold of him. He is now on the platform, so I don't know whether we received it, but we, Mr. Hubert and I, did not have any sight thereof, my lady. It's also not loaded onto case lines. We are only in possession of the initial heads of argument, my lady. So if it's only typographical and grammatical errors that were rectified, my lady, then we won't have any objection to that, my lady.
Mr. Manilal, I've not received amended heads. I've received a letter where you are indicating what you are amending.
My lady, in the second,
what the position is.
My lady, as far as I knew that the amended heads were served upon your ladyship register on the following day, because I understand that your ladyship had requested a copy of the document, track changes, as well as the track changes.
Oh, I see. Thanks for clarifying that. In fact, what your attorney did, he first filed the amended heads, and I didn't know what you are amending. So I then asked for an indication. I actually asked for track changes, and then the letter followed indicating precisely what is being amended. And as you correctly put, it's mainly typographical changes that are really insignificant. There's only one significant typographical correction, and I'm trying to get to that letter. Or maybe you can assist me so that we can, I'm raising this issue particularly because Mr. Fouchier has not seen the amended heads.
Yes, my lady, basically it's connection with what was requested, if I can recall, my lady, with regards to the last paragraph, where it was stated, wherefore the applicant prays that this honorable tribunal grants relief it seeks with costs and further or
no,
any
not
other
that.
relief.
It's not that one. Sorry, I'm trying to get to this letter. I didn't print it. If you can just be patient, please.
Thank you. Yes. If I may assist your ladyship.
Yes.
I think it would be item number 6, page 3, paragraph 4.
Yes.
Where what was added, the word that was added after the case number GP09/2019, no information
It's
or
that one.
insight furnished. Yes, my lady.
So,
There was an omission of the word no.
Yes, you see, that's a substantial amendment because it changes the meaning completely.
Yes, my lady.
Yeah, it changes the meaning completely. However, it's consistent with your case, isn't it?
Yes, my lady.
Yeah, it is
correct, my
consistent
lady.
with your case, so I don't think there's any prejudice on the respondents. Okay.
As your lady.
Okay, leave is granted for the filing of the amended heads of argument.
As the court pleases. My lady, insofar as the address is concerned, my lady, since the last conference on the 18th of August, on the 26th of August, the plaintiffs caused documentation by way of a flash drive to be furnished to the defendant. I will henceforth, if court pleases, refer to the defendant as the applicant in this interlocutory application, my lady.
Yes.
And that was receipt was acknowledged of the documentation, and on the 29th, a letter was forwarded to the applicant's attorneys as to whether, in fact, with regard to the what is called the comprehensive response, the applicant had any problems or any items that were not addressed. An appropriate letter was addressed accordingly on the basis that items 1, 3, and 7 in the circumstances were not addressed, and therefore the answering affidavit was sought from the respondent's attorneys. That was duly done, and in those circumstances, the replying affidavit was filed. So that was basically what had transpired, my lady, since the last conference. We, of course, sit here today to argue the aspects that were raised in respect of items numbers 1, 3, and 7 of the Rule 35-14 notice.
Yes.
My lady, with regard to these items, I respectfully submit, my lady, that insofar as the item 1 is concerned, and that is with reference to the brief, if I could just use as for an example, paragraph 12 of the particulars of claim, which appears at page 31 of the indexed papers. The claim in respect of claim A, and I'm confining at this stage, my lady, to claim A, it is stated that during the period January 2014 to December 2014, the head of the office of the State Attorney Johannesburg, Mr. KG Lekaba, briefed the defendant on behalf of the Office of the State Attorney Johannesburg to act in 17 litigious matters, and it goes on to state the rate. My lady, I respectfully draw the court's attention to what is stated in Rule 18.4 of the Uniform Rules of Court. 18.4 of the Uniform Rules, and I quote, states that every pleading shall contain a clear and concise statement of the material facts upon which the pleader relies for his claim, defense, or answer.
Mr. Manilal, I don't intend to be rude, and I don't intend to cut your argument. I've noted, and I'm raising this because that's the first point you're arguing on. I've noted that largely in the application, the applicant raises issues that ordinarily would be raised in an exception. So you are basically indicating aspects in which the particulars of claim either don't comply with the rules in respect of pleadings, or you are also complaining that in certain respects, the particulars of claim are vague and embarrassing. Those issues are not to be raised in this application. They belong elsewhere. They don't belong here. What you are here seeking is discovery. And what you ought to persuade me is that Mr. Kajee is entitled to the discovery of the documents that he seeks at this stage. You've come relying on Rule 3514, right? You are essentially asking the tribunal to invoke that rule because the tribunal does not have Uniform Rule 3514 because the tribunal rules don't have an equivalent of that rule. Is that not so? So I'd like to direct you to just focus on issues that are relevant in this application, because in your application and in your heads of argument, you raise issues that actually should not be raised here. They belong elsewhere.
I hear the court, my lady. I hear the court. My lady, with regards to the brief or the brief covers and or the instructions, the response of the respondents at paragraph 14 of their reply of their answering affidavit is to the effect that the brief covers are not in the plaintiff's possession. But they also go on to state, should they indeed exist? Now, my respectful submission, my lady, is that with regard to the existence of the brief covers and or the instructions, by use of the word should they indeed exist, it applies, my respectful submission, my lady, that these brief covers might well exist. And I respectfully point out, my lady, that if that is the case, then they ought to have been discovered in the sense that this wasn't the basis on which the plaintiffs had formulated their claims. So I submit with respect, my lady, that the fact that the respondents state that these are not in the plaintiff's possession, should they indeed exist, implies that there is a possibility that those brief covers do exist, or those instructions do exist in the circumstances. That is in respect of the brief covers, my lady.
Yeah.
With regard to the...
Before you move to the next point, how far does the plaintiff's responsibility go as far as discovery is concerned, given the difficulty that you've just raised? How far does their duty go? Do they have a duty to discover documents that are not in their possession? Let's say, for your benefit, hypothetically, these documents exist somewhere, but they are not in the plaintiff's possession, and the plaintiffs do not know where these documents are. How far does their duty stretch under these circumstances?
My lady, by reference to the fact that in the claim itself, the plaintiffs state that the defendant was briefed on 17 matters with no identification as to the parties that were involved in each of those matters, or for that matter, what were the instructions itself. It is difficult for the defendant in the circumstance to be able to ascertain what are these matters that pertain in respect of...
See, that issue belongs elsewhere. It doesn't belong here. Here we're dealing with whether they should be compelled to discover these documents. And hence I'm asking you, how far does does one stretch their duty to discover under these circumstances? They are saying the documents may exist, but they are not in their possession. So what do I compel them to do?
I understand, my lady. In those circumstances, obviously, of course, that will probably be subject to a different exercise with regard to the actual pleadings themselves.
Yeah, but
I hear what my lady said.
What does it mean for your case here? What does it mean for your case now that request does not succeed in terms of that first item, right?
Instead of that first item, I will concede that, my lady. I will.
Okay, you may move to the next item.
My lady, in respect of the next item, which is the collusive, that's item number 3, the corrupt, the perceived corrupt and collusive relationship between the defendant and one Mr. Lekabe.
Yes.
The response of the respondents is that this is contained in 11,192 pages of the documents were furnished. My lady, once more, the difficulty is that the position is that what was furnished are documentation that relates to various items. And again, once more, the difficulty is that with regards to the allegation as regards a corrupt and collusive relationship, my respectful submission, my lady, is that the documentation that have been furnished does not prove or does not show a corrupt and collusive relationship.
So that issue again belongs elsewhere. So you are saying you've required documents that prove such a corrupt relationship. They are saying they finished documents that prove it, and your reply is that those documents don't prove it. So for the purpose of discovery, how is that point taken further? Because you are not disputing, you are not saying they have not given you documents that prove a corrupt relationship.
My lady, I say that the documents have been provided.
Pardon?
Sorry. My lady, I say yes, documents have been provided, but those documents do not point to any corrupt or collusive relationship as alleged in the summons.
Yes, and they're saying they will need to lead evidence to using those documents, they will need to lead evidence to prove a corrupt relationship. So what do I compel them to provide here?
My lady, the documents that are relevant in the circumstances with regard to a corrupt and collusive relationship. There's an allegation that has been...
Remember, in terms of the rule 3514 as well, you must specify exactly which document is this.
My lady, with respect, in as much as that is the position, my learned colleagues had raised what was basically Rule 3512 as well. And in those circumstances had quoted the matter of Wood School, if my lady will just bear with me. This is footnote 17 of the.
It's in which paragraph? In which paragraph do I find?
This would be paragraph 20, from paragraphs 20 to 22, my lady. The respondent's concise heads of argument.
Just allow me to get there, please.
Thank you. With that on your hand, your reference.
Yes.
My lady, in paragraph 20 of the respondent's concise heads.
Yes.
Under the heading Supreme Court of Appeal Authority, at paragraph 20, it is stated that he's been authoritatively held by the Supreme Court of Appeal dealing with a request for documents under Uniform Rule 3512. It is obvious that a court will not make an order against a party to produce a document that cannot be produced or is privileged or irrelevant. And the authority for that, my lady, is contained in the respondent submission in the matter of Center for Child Law versus Wood School, Foxville, and another.
Yes.
Now, my lady, with respect, after receipt of the respondent's heads of argument, I have caused to look at a matter which I would, with the leave of the court, refer the Honourable Court to. And this is a fairly recent judgment of the Supreme Court of Appeal. If I might refer your ladyship to this matter.
Yes, I'm listening.
Thank you, my lady. It's the matter between Caxton and CTP Publishers and Printers Limited being the appellant.
Please spell the first name. Sorry. Please spell the first name.
Sorry. Caxton, C-A-X-T-O-N, and CTP Publishers and Printers Limited, the appellants, and Novus Holdings, N-O-V-U-S, Holdings Limited. My lady, it's a decision of the Supreme Court of Appeal of South Africa, and the case number 219/2021. The neutral citation, my lady, being ZASCA 24 in brackets 09, that's 9th of March 2022. My lady's judgment of the Honorable Petzer AP.
Yes.
Together with the Honorable Judges Molamela, Plaskett, Hughes, and Unterhalter. My lady, in that matter, the position appears to be somewhat different, and if I might have leave, my lady, to refer to some of the paragraphs of what is stated by the Honorable Justices. My lady, at paragraph 15 of that judgment, it is stated that there are two features that strike one about the provisions of Rule 3512, and this is in respect of 3512. First, to invoke the rule, the pleadings or affidavits of the other party must make reference to the document or tape recording concerned. Thus, any such reference will trigger the right of the adversary to require that such document or tape recording be produced for inspection, copying, or transcription. Now, my lady, I respectfully submit that the reference to the corrupt and collusive relationship will require the applicant to have sight of what is stated in respect of that. So also would be the payments that were made in respect of the item number 7, I now refer to, of the Rule 3514 notice. Item 7, the bank statements would be, it would be necessary for there to be a recourse to be had to those bank statements in order to identify what payments were received and in respect of which matter those were. Now, my learned colleague had referred the court to certain BAS payments that were made. If one looks at the BAS payments, my lady, which appears to be on case line, was loaded on case line. Bear with me, my lady. This is footnote 19 of the respondents' heads.
Paragraph, please give me paragraph number.
If the court will bear with me, my lady. My lady, paragraph 25, after the words in italic, yes. Payment bundles.
Yes.
If one looks at an example of the BAS payment, my lady, there is not much here that helps in any way or assists in any way the defendant to identify what payment was made, how it was made, and to whom, in respect of which matter. So, reference to the BAS payments, my lady, with respect, does not in any way assist the defendant, or for that matter, the tribunal, to be able to identify what payments were made. The payments were all globular in terms of the pleadings of the plaintiffs, my lady. And it is necessary in the circumstances for the applicant, in my respective submission, to have sight of the payments that were made by the various departments and or ministers. My lady, so also is what is stated at paragraph 38 of the case that I've quoted to my lady. At paragraph 30, if the court will bear with me.
Just before you move to that case, I just need clarity on the issue that you've just raised regarding the inadequacy of the BAS reports, right?
Yes.
It's stated in paragraph 25 of the respondents' heads of argument. In fact, the respondents deal with payment bundles and not just the BAS report, payment bundles. And then they itemize the information that is contained in those payment bundles in subparagraphs 25.1 to 25.5. So the BAS reports are part of a bundle of documents in relation to each payment, which appear to have more particularity. So if you're only looking at the BAS report, obviously it will not assist you. But if you look at the full payment bundle, it contains, I'm not sure if I'm the one who, can you still hear me, Mr. Manila?
Yes, my lady.
Okay. Did you get my point?
Yes, I have your point, my lady. I have your point, my lady.
Yes, I'm saying that
this
information is contained in a larger bundle. So if you focus on the BAS report, obviously you will have a problem. But if you look at the payment bundles, then that issue shouldn't arise.
I hear what your ladyship says, my lady. Your ladyship will just bear with me for a second, my lady.
Yes.
I'm going. My lady, in the circumstances, those are the points of my argument at this point in time, my lady.
Thank you. Thank you, Mr. Manila. Mr. Foshia?
Thank you, my lady. My lady, first of all, your ladyship asked my learned friend in respect of what is the duty of the plaintiffs in this matter, in terms of Rule 35.14. My lady, that is set out in our heads of argument. It is loaded on case lines under 054-4, and it is paragraph 6 of our heads of argument.
Yes.
And there we deal with the rule, my lady. Now, the duty in terms of Rule 35.14 on the plaintiffs are three things. One, you can produce the documentation, which we say we did comprehensively. Two, you can state in writing what is your objection to the documentation that is requested. Or three, you can under oath say you do not have it in your possession. And if you know the whereabouts thereof, then you can say where it is. So in respect of the brief covers, my lady, the plaintiffs tell your ladyship that it's not in their possession. Your ladyship would see that there's a thorough investigation that was done by Mr. Woman, who's the deponent to the affidavit, the answering affidavit. In that effect, over 11,000 pages were furnished to the defendant, and 6 recordings as per his request, my lady. So if the deponent says that it would seem that it's not in the files of the state attorney and it's not in their possession, then that is it, my lady. And it complied, the plaintiffs complied with the rule and their duty to say under oath it's not in their possession. And that is what Hoërskool Vogwel says, my lady, is that it goes as far to say, and that's paragraph 20 of our heads, my lady, where it says, it is obvious that the court will not make an order against a party to produce a document that cannot be produced. And that is our submission in respect of the brief covers, my lady. It cannot be produced. But the plaintiffs go beyond that, and they say they do not simply say we do not have it and we're not going to give you anything. They give the defendant the full payment bundles that your ladyship alluded to earlier. Now, if I can take your ladyship to such a bundle, it might be helpful to see what exactly is contained in that bundle, my lady. And that is loaded onto case lines. And if I can take your ladyship, it is under notices.
Okay, hold on. Let me just get to the case profile for Mr. Kajee. Yes, notices. Item
number 19 under notices, my lady.
Yes, there.
No, not 19. Let me just see.
Yes.
Item number, it's earlier. Payment bundle. Item number 6, my lady. Item number 6 under notices. And if I can ask your ladyship to scroll down to page 002-26.
Okay, hold on. I might have to download this document because case lines tends to be very slow when one is trying to get to.
Yeah, unfortunately, mine also froze up this morning, my lady, so I did download it.
Just give me a few seconds. It's downloading.
100%, my lady. In the meanwhile, I can just address your ladyship on...
I'm there. I'm there. Let's just deal with this.
You,
almost. Just get it on. Yeah. Which page?
002-26, my lady. Before I take your ladyship... Before I take your ladyship through one of those bundles, what is important to note is what the defendant complains about in his replying affidavit is he says it will be virtually impossible for him to identify any matter referred to in the plaintiff's claims or to ascertain the charges for the services rendered. Now, all of that your ladyship would see is very easily can very easily ascertain from these. The first document, that 002-26, is the sundry payment advice. Your ladyship will see the name of the defendant appears on it, Advocate Kajee.
Yes.
And at the bottom of that page, basically, there's a heading office use, and your ladyship will see that it refers to Lorna Nevling on behalf of Ishan/Health, and just to the left on top of that, it is the amount to be paid is just over 48,000 Rand. Now, if your ladyship scroll down, the next document, so that is the sundry, what we refer to in the heads. Then the next document is the defendant's own invoice, and it is in the interim fees due for Nevling, Lorna on behalf of Ishan versus MEC for Health in Gauteng. So it's clearly the same matter that we are referring to. The third document in that payment bundle, still dealing with the same matter, is 002-28, And that is a letter from the Gauteng Province Health to the Office of the State Attorney, and the third paragraph or the third sentence says, kindly appoint counsel as well as relevant experts in preparation for the trial. And the next document on 002-29 is that document, an internal document of the State Attorney, where it shows the surname of the counsel is Kajee, H-E, and in one of the ticked boxes, your ladyship will see counsel was appointed as the office head's choice, and that is Mr. Lakabe. And it is in respect of the matter is also written there, the Neveling matter versus Gauteng Health, and it is signed off with a date by Mrs. Smith showing that payment took place. And the very next document is the BAS report that your ladyship alluded to on 002-30. So, my lady, all that the defendant is complaining about, that he cannot identify the matter or ascertain the charges, my lady, it's not so, because that is all in each and every payment bundle. Your ladyship will see these payment bundles are over 3,200 pages. So it deals with each and every claim of the plaintiffs in the particulars of claim. So we say it's vexatious of the defendant to submit to your ladyship, him being an advocate of the High Court, to submit to your ladyship, he cannot ascertain those knowledge from the document that is being presented to. And to get back to your ladyship's question, the duty, the plaintiffs complied with their duty. Under oath, they said they do not have the brief covers. So with respect of the brief covers, my lady, I submit that that part of the request for to compel the plaintiffs to present the brief covers or to produce the brief covers, that should be dismissed with a punitive costs order, my lady. The second issue is the unspecified documentation. And my lady, it's quite clear, and even from argument from Mr. Maninal this morning, it is clear, he said, those documents does not prove that there's a collusive and corrupt relationship. But for that argument to have or to hold any water, my lady, there needs to be evidence before the court, and that can only be dealt with at trial. What the plaintiffs tell your ladyship is that these are the documents that we are basing our claims on, and we will prove it at trial stage. At this stage, we can't present anything more to the defendant in respect of that, because, well, first of all, there's nothing specified by the defendant in respect of these unspecified documents, and they've received over 11,000 documents that the plaintiffs say that is our case. We are basing our case on that. So also on that item, my lady, I submit that the court cannot compel the plaintiffs to furnish any further documentation to it. And as is set out in our heads, my lady, in any event, this request does not comply with Rule 35.14. And also that item should then be, or that request should be dismissed with a punitive costs order, my lady, because the defendant does not even comply with the rule in asking for unspecified documents. My learned friend referred to the Caxton matter dealing with Rule 35.12, but we all know if you are referring to a specific document, then in terms of Rule 35.12, the other party can request that specific document. However, this is not an application in terms of 35.12. This is an application in terms of 35.14, where it requests certain other documentation, not documents that's referring to. And even if this was an application under 35.12, I submit that would not assist the defendant, my lady, because the plaintiffs do not refer to a specific document. They say this is their relationship, and then they present a bundle of over 11,000 documents, my lady. The third item, my lady, is the bank statements. Now, we already had a look at the BAS statements that itemize the everything as per the payment bundles, my lady. There's a date on which the payment was made. There's the name of the defendant appears on it. It's been paid to him. The amount appears on it. And it's in respect of his specific invoices, my lady. And it's grouped together like that in the documents so provided to the defendant. Furthermore, my lady, your ladyship will see under item under notices and under item 20 on case law case lines, there is the entire under item 19. It's under notices, item 19, and those are the BAS report, the entire report. That consists of over 700 payments, 574, I beg your ladyship's pardon, 574 payments that were made to the defendant. It shows it's been paid from Justice, or Department of Justice in the national, so it's from National Treasury. It shows the amount that was being paid. It shows the date on which it was paid. It showed that it's been paid to Advocate Kajee, and who made the payment, in most instances, Lorraine Smith from the State Attorney in Johannesburg, my lady. So on those 10 pages also, all the payments that's been made to the defendant is presented on that, over 500 of them, my lady. And furthermore, the defendant cannot complain that we do not show the payments that's been made, because we also furnished with his own bank accounts, my lady. He requested his own bank accounts from the plaintiffs. We furnished him with that. And on all of those bank accounts, the payments, as is set out on the BAS reports, reflects, my lady. So he received it. He can't complain that he does not know what was paid to him and what was received by him. All of the documents are there, my lady. And once again, we submit it's vexatious of the defendant to attempt to compel the plaintiffs to furnish their bank accounts to it, because all the payments are shown on the BAS reports, my lady.
Your case is that the bank statements are irrelevant.
Totally irrelevant, my lady. So the plaintiffs will not need the bank statements to prove payment. They will use the BAS reports to prove payment.
But remember that the requirement in terms of discoveries if documents are in its possession. Now, I'm just trying to understand the plaintiff's objection.
Your ladyship will recall in the Vogel matter, the court says it is obvious that the court will not make an order against a party to produce documents that cannot be produced, is privileged or irrelevant. So yes. The Supreme Court of Appeal says it's irrelevant. The plaintiffs say it is irrelevant because the payments that we rely on is shown on the BAS report. Yes. Remember, all payments made by National Treasury is done in terms of the BAS system. Yes. That BAS system gives a report. The first report is annexed to each and every, shown together with the invoice that was paid in the payment bundles. Yes. And the second, where you can see it, is on the BAS payments made to him on these pages that I referred your ladyship on a notice.
You're saying they also reflect in his own bank statements.
In his own bank statements, my lady. So once again, it's vexatious of him to request something that he's already got all the information. And that's why we say bank statements will be irrelevant. To ask the bank statement of the SIU will not assist at all, my lady, or any of the other departments cited as plaintiffs in this matter, because it was made by National Treasury. And how do you see National Treasury is making a payment? That is reflected on a BAS system report. Those are reflected twice in the documents furnished to the defendant, once together with his invoices and the payment bundles, and the second one, all of them are listed, the 574 on that one, or the 10 pages, that one document, Malik. That's why
you're saying these payments are from the National Revenue account. So they're not from an account held by a specific government department.
No, it's from the National Treasury, my lady, yes. And that will reflect on the BAS statements.
Okay.
So that's why we say that's totally irrelevant, and once again vexatious of the defendant to ask that, my lady. So in all three issues, my lady, and your ladyship will see we've made out a case on the heads of argument that for a punitive costs order against the defendant, because he is vexatious and frivolous in seeking this order. And we are only seeking the costs since the further reply was delivered on 26 August, my lady. We say every step that was taken by the defendant thereafter to persist with this application should be seen as vexatious and frivolous, especially in light thereof that he is an officer of court still. He is still an advocate, my lady. With respect, you should know of better than to bring an application like this. And therefore, we say your ladyship should, frown upon this and give a punitive cost order against the defendant in respect of this, which should include the cost of 2 counsel, my lady. My lady, there's one issue that I do need to quickly address your ladyship on. It was not argued by the defendant, and it's not contained in its heads of argument. However, in the replying affidavit, the respondent says at paragraph 2 thereof that Mr. Woman, the deponent to the answering affidavit, did not initial each and every page of the affidavit, the answering affidavit, and therefore it falls short of the requirements in terms of the Justice and Peace of Commissioners Act. My lady, that is, first of all, that's incorrect, because all that the regulation says is that the deponent must sign the declaration in the presence of the Commissioner of Oaths. It doesn't say it must initial, and then the Commissioner of Oaths should then ask him the questions, whether he agree with the content thereof, and then sign the declaration and print his full name. So the initials are not necessary. However, once again, the plaintiffs went over and beyond, my lady, and Mr. Woman once again attended the Commissioner of Oaths, Cherise Botha, and he then initialed that one page that he missed. Your ladyship will note the page that he did not initial initially was page 10, and page 10 of the answering affidavit is only the second portion of the oath and contains only the signature of the Commissioner of Oath, Cherise Botha. But Mr. Woman now once again in her presence initialed this, and she initialed next to that. We did not upload that to Caseline because we do not have your ladyship's leave, but the full initialed document can be uploaded with your ladyship's leave, but we submit nothing turns on that in any event. I just wanted to cross the T's and dot the I's and make sure that that does not come relevant later on, my lady. We submit a proper affidavit is before your ladyship. However, there is now one that is also initialed on page 10 there.
Yes.
Those are my submissions, unless your ladyship wants me to address your ladyship on anything else.
There's an issue that arises on the papers. Mr. Manilal did not deal with it, but I'm raising it because this is the only opportunity you have to address me, and then Mr. Manilal can deal with it in reply if he so wishes. And that is what happened to Mr. Kajee's laptop. Right. There's a dispute on the papers regarding, who tampered, whether the laptop was tampered with or not, and who did so. Because the SIU is also saying that it appears that it had been wiped off before it was handed over. In his replying affidavit, Mr. Kajee makes the point that I should decide what to make of that issue, and what's your submission in respect of that? Because you didn't deal with it in your heads at all. Yes. Neither did Mr. Manilal.
Yes, well, lady, I submit that that is not relevant for purposes of this application, my lady. That's basically a red herring and a side issue that may very well be forming part of evidence that will be led at the trial stage. But for purposes of the Rule 3514 application brought by the defendant, I submit that is totally irrelevant.
Okay, thank you.
Thank you, my lady.
Mr. Manilal.
My lady, on that issue with regards to the laptop itself, as have been indicated, my lady, I'm at your ladyship's. I leave it to your ladyship to make a decision with regard to that. Insofar as the documentation is concerned relating to the brief covers, as also the payment bundles, my lady, may I respectfully refer the court, my lady, to the matter of the Caxton, the decision in the Caxton matter. And in this respect, I refer your ladyship to what is stated in paragraph 38 of the decision, the judgment, that is the middle of the paragraph, and I'd like to just quote my lady, where the learned judge says, accordingly, in the event that a court seized with an application to produce documents subject to the Rule 3512, this is in relation to Rule 3512, the Rule 3512 notice concludes that the documents sought to be produced, A, have been referenced in the adversary's pleadings or affidavits, B, are relevant, and C, are not privileged. The application for their production must, in the ordinary course, necessarily succeed. In these circumstances, my lady, I respectfully submit that with regard to the brief covers, I hear what my colleague has stated about saying under oath that those brief covers are not in the possession of the plaintiffs. But reference has been made to the briefs, my lady, as also with regard to the relationship between the defendant and Mr. Lekab. In those circumstances, my lady, I submit with respect that the Caxton judgment is somewhat different from that of the Wood School matter. And I ask your ladyship to take into cognizance what is stated in paragraph 38 of that judgment, my lady. With regard to the costs, my lady, my little colleague required the court to look at punitive costs. I submit with respect, my lady, that with regard to the fact that this application was brought initially, the application itself was not frivolous and it was not vexatious. And the defendant, the applicant in this instance, believed that the documentation that he required in respect of the brief covers, that is items 1, 3, and 7, were necessary in order for him to plead. My lady, I submit with respect that although I don't have authority, but bringing in the application itself was not frivolous or vexatious in the circumstances. And therefore, my lady, I ask the court to consider no punitive costs in the event of your ladyship deciding costs in favor of the respondents. Those are my submissions.
Mr. Manila, the respondents are not saying bringing the application in and of itself was vexatious. They are saying persisting with the application after the 26th of August was vexatious.
My lady, my respectful submission, again, I don't have the authority.
Not the full cost, just those costs after the 26th of August.
My lady, my limited understanding of matters that are frivolous or vexatious would apply to pleadings in the circumstances, not to applications. This is my submission, in my limited in these circumstances, my lady, these are not pleadings, this is an application. I ask the court, my lady, that in the circumstances the court ought not to rule in the circumstances the furtherance of the application was frivolous or vexatious. They're talking about the cost. My lady?
Sorry, Mr. Manilal, I got disconnected.
Yes, my lady.
Yes.
My lady, the last submission I was making in respect to what transpired after the 26th of August. My lady, my limited exposure is that in matters where pleadings are frivolous or vexatious, the court can make a ruling. But in these circumstances, my lady, my respectful submission is that this was an application. In those circumstances, I ask the court, my lady, not to make such a ruling. In the event of your ladyship deciding that costs be payable in favor of the respondents.
Thank you. Okay, we've come to the end of the proceedings. Thank you very much, counsel, for your assistance. Judgment is reserved and the proceedings are adjourned.
As you wish.